Hello to everyone. I hope you're still hanging in there. The semaine d'études libres is about 2 weeks away, so you will get a break at some point. We were talking last time about defamatory speech. We looked mainly at the United States. We also had an introduction in the common law, the classic common law, which I explained is not very free speech friendly, and we saw the constitutionalization of the tort of defamation in New York Times versus Sullivan, where the approach was changed quite fundamentally. We also saw that Sullivan is being discussed. Some justices feel nowadays that it goes too far, that because it virtually grants immunity as it is applied when the target is a public figure. We also then wondered what in today's context, whether it would be a good thing or not to overrule Sullivan. Obviously up to you to make up your own mind. Just for the exam, it is important you know Sullivan, that you also know what this New York Times privilege is, what concretely you would need to prove in a defamation proceeding. And you know, should you have questions, we are here to answer them, so don't feel shy. Today we will broaden the analysis and travel first together to other common law jurisdictions. We will discuss together a case by the Canadian Supreme Court, but I will also tell you what happened in the United Kingdom. And you may have seen when you read the case Torstar for today that there is actually reference also to the United Kingdom. We will then read together a seminal case, which is really a foundational case of freedom of expression in Germany, and which also shows one approach of handling conflicts between fundamental rights. On the one hand, that can be, in that case, it was more economic interests which were concerned, but you can apply the same thing to reputation. I think we have students from Germany, so yes, you have heard about Lüth, I assume. So I'll be relying on you to help me a little bit with that case. And we will also look at the European Court of Human Rights. You may be wondering why were we given a case on privacy and not on defamation. But actually the court developed its framework, which it applies both to defamation and to privacy in the cases I have given to you. And I have chosen them because actually there was some development of the case law in a ping-pong between Germany and the European Court of Human Rights. Germany was very unhappy with the first judgment, and the European Court basically then changed its approach a bit. We will be discussing to what extent there has been a change. And I would say underlying also a common theme you may have seen also in these cases is, what about public figures? To what extent should they be granted, or lesser protection? What justifies this? It's very prominent in von Hanover. So a full menu, but we'll make it. When we first look at the United Kingdom, so in the United Kingdom, there were also cases where basically the plaintiffs said, or the defendants, or the newspaper said, look, the common law is too strict. We should get inspired by other common law jurisdictions. Sullivan was mentioned as well, but the House of Lords basically refused to take into account Sullivan, thinking that that would be too protective of freedom of expression. But they introduced their own approach. And basically the idea is that sometimes journalists should be able to get away with publishing something which objectively might be false, or they may not be able to prove sufficiently that it's true, but you still want that journalists act responsibly. The House of Lords then laid down a set of criteria saying, well, we should look at different criteria to assess were the journalists diligent enough. They actually called it also an elastic approach, saying it's more case by case. We don't want to have strict rules. It's not the Sullivan approach where you say if the plaintiff is a public figure, extremely difficult to get any damages. You see that here is a whole series of factors such as the second one is very important. Is it a matter of public concern? How serious are the allegations? Were there steps taken to verify it? How important was it to publish? Was it urgent? Often journalists will tell you it's urgent. We want to be the first ones. We can't wait too long. Was the story of the plaintiff included, etc.? Now, when you read Torstar, did anyone see some criticism of Reynolds? I can see someone nodding. Yes?
I think, so they created this elastic approach, but then the way that it worked in practice was, instead of being just factors to consider, these became like factors that created a high bar that required newspapers to, they became like hurdles. They needed to prove that they did every single one of these things.
And I think you've summarized it very well. So basically, already the case law was not always very consistent, but there was a tendency to say, this is like a checklist. Tick the box. Did the newspaper meet all 10? And if not, well, it was reputation which prevailed. You have the summary of the criticism in the Torstar case. Just maybe someone's faster than me, but you have a summary of Reynolds. It's on page 136 of the reader, paragraph 70. A summary of these 10 factors, and that generally this was like, as you said, hurdles to be surmounted. So there was criticism from the freedom of expression perspective saying, well, there was a privilege introduced, but it's not, hasn't gone far enough. I think it's probably, I'm not a lawyer in the United Kingdom, but I think whenever you change something, so the judges were still used to the traditional common law approach and then probably admitted this defense quite restrictively. There was then basically a reform, a Defamation Act, which was adopted in 2013, an act which was taking into account criticism. Also, the Human Rights Committee was critical of the UK as saying, well, you know, the Human Rights Committee is the body which oversees the supervisory body of the Covenant on Civil and Political Rights. And they also basically stressed that there was a lot of incitation to libel tourism. So people would try and create a jurisdiction in the UK because they knew that it was favorable to reputation. I told you, I gave you an example last week, I think, with this film, The Denial, the professor who criticizes a Holocaust denial and she's in the US and gets sued in the UK. So the Defamation Act tries to take into account these criticisms, and basically it is, you can see it doesn't mention any factors anymore. It basically just says we have to check whether the publication is of a matter of public interest, a concept we will be returning to. It's easy to say, but what does it mean concretely? And then comes this the other element, which was in these factors as well, did the defendant act reasonably? No list, no checklist, so that leaves a bit more, I would say, leeway to consider everything. But it's interesting to see there was basically an influence of New York Times and this movement in the US to say we have to be more protective of freedom of expression, but it was not a direct reception of Sullivan, but it was basically what you could call cross-fertilization, saying, well, we will do something, but something which we consider fits better our own context. Then I have introduced these slides just because I read this book, Silenced Women, and I remember I thought it was interesting. Why? Because you would, it recounts, one of the authors was the lawyer of Johnny Depp's wife. I don't know if anyone followed the whole thing. Those who followed, what was it about? Someone? Basically domestic violence, domestic abuse, and basically the Sun first published an article in the UK saying that Johnny Depp is a wife beater, and he sued for defamation against the Sun. And I noticed that a lot of people think that it was actually Amber who sued Depp. No, she was called as a witness because obviously to know if the story was true, well, she had to appear as a witness. And actually, she won, or the Sun won in the UK, whereas you would say it's more difficult in a way, legally speaking. You don't have a New York Times versus Sullivan defense. Then there was another trial in the US, same facts, and more or less, and there it was basically, you would say, well, obviously Johnny Depp is a public figure. So New York Times will apply, so it will be very difficult, to say that actually these statements were made with actual malice, but surprisingly he won. So sometimes the legal framework does not explain it all, and I haven't followed it so closely, but basically one explanation is it was a trial by, it was the jury, very favorable to Johnny Depp. The lawyer who obviously has one side also of the story, but says it was just, there were so many Johnny Depp fans already outside the courthouse. It was very difficult for Amber, basically, even to get in there and to feel that the whole public opinion was against her. So I'm just flagging this, not because I want to tell you what you should think about this trial. I haven't followed it myself, but I thought it was interesting that the outcome was actually not what you would have expected, just based on the legal framework. The book Silenced Women, quite interesting. It's written after the Me Too movement and trying to show how still there are a lot of, can be defamation lawsuits, other types of lawsuits, which actually prevent women from speaking up, which counters a bit this narrative that nowadays, basically, you can say anything, anything goes, etc. Now let's travel to Canada. Torstar is not the first case in which the Supreme Court was invited to rethink the defamation law. It was already asked to do so in Hill versus Church of Scientology. What is interesting in that case, in the ideal world I would have given it to you too, but I think you had enough reading. So basically the Supreme Court, the flat rejection of New York Times versus Sullivan and saying we keep the common law as it is. I don't know, is there anyone from Canada who knows the case?
I don't know the case.
You don't know. It's interesting when you start reading it, there's pages and pages on reputation. And the history of reputation, starting with the Talmud and so on. So you can quite easily feel that the judge who wrote the opinion was more sensitive to reputation than to freedom of expression. And the argument was to say, well, New York Times versus Sullivan was very much dependent on the political context. It was desegregation, it was the fear of the viability of the press, and so the case law may have gone too far. And then an argument which is also made, what was not considered, and that's why I think it was not the best of reasoning, was the chilling effect. You can be against New York Times, but I think you have to mention at least that the idea was obviously not to say that anyone thinks false statements as such are valuable, but you protect false statements sometimes because you think, well, if people don't know when they can speak up and if they are not sure whether they can prove, that something's true, that will be, true speech will be chilled. That was not mentioned at all in the Hill judgment, but what was mentioned was that basically politicians would not go into politics. Decent ones won't go into politics. This is what some authors call the reverse chilling effect. So if you don't protect also politicians' reputation, that will basically have a dissuasive effect. I haven't seen any studies, is there such a dissuasive effect or not? What I get the impression that nowadays people talk more who are in politics about hate speech, about getting basically when they appear somewhere and attacked quite viciously in big. I think I get the impression that's the bigger problem than defamation. But, I haven't done any study on that. So interesting, a flat rejection of New York Times. And not an attempt maybe to think, should we change the common law? Just we leave it as it is, it's good enough. And now you have the Torstar case, which actually does take a different approach. So to my knowledge, this is the latest case, but before we get to Torstar, I would just like to mention there were other cases which also, I would say, made the common law a bit more free speech protective. One case is this WIC radio case, where basically the defense invoked was fair comment. Fair comment, it's basically, I would to use a terminology of the European Court of Human Rights, it's more something like a value judgment. So you do criticize someone, it's a criticism, which is more like an opinion, but you would still expect that the person uses some factual elements. So that is what makes it different from pure defamation, where it's only about statements of facts. And there is a fair comment defense, where you can see the comment must be on a matter of public interest. It must be based on fact. And you also have to make sure that it's recognized as a comment. So that has to be opinion and facts, not always that easy to separate. And basically then there's the fourth element. The comment must be an opinion that any person, including individuals who are especially obstinate, prejudiced, or exaggerated, could honestly express. And it's on this fourth element that was changed. Before it was, it's also in Torstar, there's also reference to this case. And I think what you can also see as a change, that you say any person. The reference is not some honest, reasonable person, but which any person could have, even someone who's obstinate, prejudiced, or exaggerated. So that is not the reference of the average person. You can be obstinate, prejudiced, or exaggerated. And just to give you a bit of context, in this radio show, it's a well-known, I don't know, do you from Canada, you know that show? No. So it's basically someone who will, when you call something a shock jock or a radio talk show, you can imagine that it's something provocative. And so it was an interview with someone who was basically opposing the LGBTIQ the movement and being very critical of the LGBTIQ movement. And the radio, the person, the commentator basically said that he condones violence. And that's why the person sued, saying this is not true, I've never called for violence, but it was considered, if you take the very negative statements, that you could still reasonably somehow as an opinion say that you consider this may lead to violence. So this was already one move, I would say, in the common law in Canada, make it more free speech friendly. Then Canada also has anti-slap legislation. Anyone remember what a slap is? Strategic lawsuit against public participation. So the idea is that it's often frivolous lawsuits where it's often a corporation suing, I don't know, activists or basically someone with a lot of money thinking, well, actually, maybe we don't even think we have a good case. But we will keep the other one busy. The other one will suffer in court, and we will make sure this will last a long time, and they will have high lawyer fees, etc. So it's interesting to see that in Canada, some provinces like Ontario, they adopted legislation against slaps, which basically means that the court can basically say we will not examine this case. We will just dismiss it based on the fact that we think this is a slap. There are conditions to be met. One is basically that it is about public interest. So the idea is here again, we should protect free speech because it is on important matters. And also you have to show, and there you can still see that you will partly deal with the merits, that this lawsuit is in a way frivolous. And also they will do a comparison, the public interest as compared with reputation. So it will play a role, has someone really suffered some damages, concrete damages, big financial losses, or not. There are a few cases here, you don't need to know them. I just mentioned Hansman versus Neufeld, which is again about the LGBTIQ community. It was basically, now there was being, in school there were actions now being taken that people would be taught about transgender and all these issues. So the idea being in school you have to create a climate of tolerance, etc. And I think now I have a doubt who is who. But one of the parties basically then reacted, mainly also in public media, criticizing that this is not the role of schools and being very critical of the whole LGBTIQ community, which then there was a response by a gay teacher. You can imagine not a very polite response. And the person who basically was critical of the LGBTIQ community sued for defamation, saying, I have been attacked by this gay teacher, that went too far. What I thought was interesting in this case was that, so it was dismissed as a slap, but also that the court took into account that this counter speech, so the gay teacher answering to the critique, was a defense of a vulnerable or marginalized group in society. And it engages values close to the core of Article 15, dignity, equal worth. And basically it considered that this counter speech was really close to the core of free speech values. And I would say what is interesting here that you do take into account in a way who is the target of the first speech. I'm not sure an American court would do that. Do you think an American court would do that and say, well, but you see this is about a vulnerable group, etc. And there we may give it more protection than if it were the opposite? Who has an idea why an American court, I think, I haven't seen, may not do that?
The US, in general, in their free speech defenses, they're trying to be as content neutral as possible.
I think it would
so
be.
we don't have hate speech laws.
I think it would be a problem of content neutrality. They would say it doesn't matter on which side you're on, whether you're in favor or against the LGBTIQ movement, we have to be content neutral. And we will be talking about hate speech next week. So we will see actually examples in that sense. So I feel here the approach is quite different. We will also see it in Canada when we'll be talking about hate speech laws, the hate speech cases. Now when we look at this case you read for today, Grant versus Torstar, maybe just a quick reminder of the facts. So it was basically a publication, a newspaper publication, which made the allegation that there would be a golf course built and that the person basically who wants to build it has a political connection and that helps to make it happen. And then the newspaper got sued, and the question which was before the Supreme Court was, do we stick with the traditional common law or should we adapt it? Now, what was the outcome in a way? Was there a change, and if so, what type of change to the common law?
There was a change. They added a new defense for publications on public interest, and so it was like a two-part test. Was the publication about public interest, and can the publisher show that they were diligent and responsible in trying to verify the allegations contained in the comment?
So you're right in saying the court introduces a new defense. So it's an addition to the existing ones, to fair comment, etc. And two elements you have to demonstrate. It's the public interest again. We will have a discussion in a while. What is a public interest? And secondly, there's also this idea, or there's the idea that you still have to act reasonably diligently. Now, how does the court, in a way, justify this change? In Hill, it said, well, let's stick with the common law, everything's fine. And all of a sudden, well, Hill is not good enough anymore. Anyone seen some of the reasons the court advanced? Or think, if you haven't maybe had time to read the whole case, you can also, what would you advance? You have to, now you're changing your case law.
I mean, the Chief Justice made a lot of kind of comparisons with other courts around the world, and then said that the Canadian one is very kind of based on qualified privilege, the law defamation, and it's very strict, and it compared it to kind of the US on the other side of the equation than like the UK and Australia in the middle, and I think kind of referring to these other countries having very different constitutions in terms of law defamation, saying so ours is too strict, you know?
So I think it's an interesting example of comparative constitutional law analysis. What did they look at? They looked mainly at common law jurisdictions, and what they said is this argument they call it, I think, from jurisprudence, saying we can identify a trend in a way, or we could put it differently, we're now almost on our own. All the other jurisdictions somehow made the common law evolve, not as far as Sullivan. I think there Sullivan is a bit on its own. But if you look at Australia, New Zealand, the UK, etc., South Africa, I haven't left everything in there because it's quite a long judgment. There is a trend. So that was one reason. So you can see here comparative constitutional law used also to justify an evolution of the case law. And the other one, they said, so we have the argument from jurisprudence, and then we have the argument from principle, and the principle would be what?
The most Canadian thing possible. We need to balance the reputation and the protection of the reputation on one hand and the protection of free speech on the other, and can we be nice to both sides? Yeah, she argues it very in a very Canadian way. It made me laugh.
You mean the Canadian? Okay, let's be nice to everyone. So. And in the balancing, you may also have noticed that they take into account the values underlying freedom of expression. At the beginning of the course, I gave you we discussed what justifies protecting freedom of expression. And the Canadian Supreme Court refers to these different values. Say you have it, for example, on page 131, paragraph 47, they talk about democratic discourse, truth-finding, and self-fulfillment. And then they look at these different values, truths, the marketplace of ideas, etc., self-realization and democracy. Which one seems the most relevant, or which one is not relevant according to the court? Yes. So the court basically this idea of self-fulfillment, self-realization is not the best of arguments, because then we have just a conflict of rights. It's my right to say whatever I want, and on the other hand, there's the right of the person to reputation. So the court relies much more on democracy. That is how the public interest fits in. And I think truth you can also adduce by saying, then you link it to another argument, the chilling effect. Saying that the common law as it stands, and there's a lot of insistence on that as well, basically has a chilling effect. And often these trials will take a long time, and you have to prove, the statement may be true, but you may not have enough evidence to back it up and to convince a court. So if there is a chilling effect, true statements, criticism may not come forward, and we may not find the truth about certain issues. So the argument from principle is connecting the problem to the free speech values, insisting on the chilling effect, etc. And the court then finds, well, we have to shift the balance towards freedom of expression. Now, would you say, do you see differences? What is different when you compare it with New York Times or Reynolds? When you look at the solution they arrived at, this two-pronged public interest defense, and you have to act also responsibly. Anyone, if you had to write now, imagine, it's a question you have at an exam. Is this the same as New York Times? Yes or no? What's the difference in a way?
The Canadian part is more restrictive than New York Times versus Sullivan. For example, they do mention criteria, so not just the journalist criteria. So that's the easier to prove that, to put a lawsuit against someone saying something.
So clearly the threshold, the faulty element is different. Actual malice, we saw it's it's wrong, or you act with reckless disregard for the truth, which we said is extremely difficult to meet, subjective standard, etc. You have to demonstrate it with clear and convincing evidence. Here, the second part of the test, you can still say, I think you can still prove that basically the newspaper was careless, it didn't do a good enough job. So the fault requirement is different. And I would say the first element is different too. In New York Times, it's about the plaintiff. Who is the plaintiff? Who is the target of the expression? Is it a public figure or not? And that's not the same. Here it's more the subject matter. What is it about? Is it about a matter of public interest? Do you see the difference? You could have also something involving private individuals, which could turn out to be on public interest. So you look more, what was the article about, the content, not just who is basically targeted. Is it O.J. Simpson, someone very famous, etc. So I would say it's not the same. Now, when we look at the different factors, how do we establish what is of public interest? Is it the same as, is it an empirical question? Let's see what interests the public. That's one approach, yes?
It says that where there's difference litigation in the public interest involves factual issues, and that when the judge decides it's of public interest, it has to really take care of that question, and that really if a lot of people would have interest in knowing the facts or not. It's just that it can be on different subjects, even if most people won't really mind about it.
So you're saying it's not a quantitative issue. It's not me doing a survey and saying, what are you interested in? It's not. So what is it about then, if it's not about?
Politics can be seen as something important to create public opinion as well. So if that is something people need to know.
So it's clearly it's not. It's important. It's not an empirical question. It's not what interests the public. Maybe a lot of readers, if I did an empirical survey, will be interested much more in the love life of a celebrity than, I don't know, about some policy issue. And they say so quite clearly on page 139. Then it's paragraph 102. Public interest is not synonymous with what interests the public. And then they basically say there needs to be a genuine interest. In paragraph 104, it must be a legitimately concern or interest of people. So it's more a normative approach. It's in a way linked again to democracy and say, we have it again. Then on paragraph 105, they give some examples. It is about the welfare of citizens, there has been some substantial concern about it. And again, in the same paragraph at the end, it's not mere curiosity or prurient interests. There has to be a genuine stake. But it could be, and someone said that, even a smaller community, maybe just it affects the public interest of certain groups and others may not be concerned. Do you think, well, can you see what might be a problem with this approach or a difficulty?
I mean, anything can become a matter of public interest, I suppose, as long as it affects or is of interest to at least one person.
I would say it is more a question of line drawing. How will we draw the line? What is of a public interest, normatively speaking, and not just because it interests the public? And when do we have to say it's just a mere curiosity of readers? And courts will often struggle a bit with that. They clearly say it's a matter of public interest. It's not just about politicians. It's not just about government policy or so. So it's not it's not something too restrictive. But then if you make it broad, you could imagine, for example, you criticize a corporation, right? You criticize, returning to slabs, McDonald's. You might say this is not a political actor, but it's still about issues like health and the environment, etc. But how to draw the line, that can be a challenge. Some authors have claimed, well, either it's too narrow or you make it so broad that anything is a public interest. It could be interesting to look at the case laws of different jurisdictions and try and define what they feel is a public interest. So you have that element. And then the second element is basically then it's more, again, it's more linked to whether the communication was responsible. Where they do give a few also, you have then factors like the seriousness of the allegation, etc. I get the impression they took quite a bit from Reynolds. The question to be seen, will that create the same effect as in Reynolds, that basically it will be more like a tick-the-box approach or not? So I would say it's rather closer to Reynolds than certainly to New York Times. And do take note of the fact that it's not about what interests the public. Any question on that case, which I think is interesting because it shows also how comparative law is used, basically not as the sole reason to make the case law evolve, but as one important reason. There are no questions. Let's move on to the Lüth case. Just a few words about the German Constitutional Court. So a court which basically sits in two senates, as they are called. And to be a member of the court, basically you have, some are selected from the highest courts. In Germany you have a system where you have, I think it's 5, isn't it? 5 highest courts for example, labor law, social security law, criminal law, etc. So you will take some constitutional judges from these highest courts, and the others then will be, and also important, the others will need to have special judicial training, minimum age, different from the Conseil Constitutionnel, where I told you there was no requirement. And both chambers of parliament designate 8 judges. We have here a system with one term, 12 years, not renewable. Different from, for example, Switzerland. I told you our Supreme Court, we have 6 years terms, which are just renewable without limits, and but different from the US as well, not for life. Also, an issue which sometimes arises, can a court basically write dissenting opinions? In Canada, in the US, dissenting opinions are quite frequent. In Germany, they are rather rare. They do exist, Sondervoten. I'm turning to the German students. Would you confirm that? It's not standard to have a Sondervotum. It's a court which is considered as, I would say, a strong court. It has a lot of different powers. It can proceed to carry out abstract review, something, for example, the US Supreme Court can't do, and also concrete review of legislation. It has also some of famous judgments of the Constitutional Court are, for example, about treaties. Are the EU treaties, the Maastricht Treaty, the Lisbon Treaty, in conformity with the Constitution? So before a treaty is ratified, the court can review basically the treaties and their conformity with the Constitution. And the Constitutional Court has, I would say, handed down judgments with some criticism of putting in place some limits to European integration. Very important, and this is maybe the most important part of this for this course, is what you call the constitutional claims, Verfassungsbeschwerden, where an individual can basically reach the Constitutional Court after having gone through the different levels of review, saying, look, here there was a decision, an act, which basically infringes my fundamental rights. The Lüth case you have read for today is a Verfassungsbeschwerde. It's not questioning the law as such. It's not saying that the civil law is unconstitutional, but it questions how the civil law has been applied. Which brings me to the Lüth case. And you have seen it's a call for boycott. So there's a filmmaker, Lüth, who basically is outraged, saying it's impossible that Harlan can again show his films. He was a Nazi filmmaker. He was notorious for this film, Jud Süß. And you can already, just looking at the image, it gives you an idea, you know, what of the anti-Semitic content of the film. Now, it is a very important case. Why do you think it was important? Let's first collect a few ideas. The German students most welcome to give their input.
It's very important to offer the determination of the basic law and private law, like the basic rights are also influencing the relationships between two private persons.
So there is one point, it is more important, it's not just about free speech. It's about the relationship between private law, like the BGB here, which would be the civil code in Switzerland, and basically the constitution. And the court here basically, we will see after the break what the court decided, but it certainly rejects the point of view that civil law, that the constitution has no impact there. That's a zone which just a pure private law dispute, so fundamental rights do not apply. Any other idea? Anyone else? Oh, you wanted to say the same thing?
I wanted to say a similar thing. So basically, the German basic rights are rights from the individual against the state. And here, Ruth was claiming that someone said something against it. It's not really reasonable for him to say because the other person is a private person as well, not the state.
Mm.
And that's why the court was deciding whether these basic rights also applies throughout the process and only the state and the person.
So we are with this Drittwirkungsfrage. We will see what the court said after the break. And we will also see that it is an important case for freedom of expression too. But it goes beyond free speech. And just maybe, you can have a question on Lut at the exam. It's a typical exam question, why is this an important case? So don't gloss over it, thinking, well, it's Germany and whatever. Let's have a break.
be so fair, but that's also it's scary. That's a strategy I often go for. But then also how do you, that's it.
I suggest we resume. We were discussing Lüth, and we already heard that it's an important case about the relationship between private law and also the Constitution. So it's not just limited to freedom of expression. And you find that basically the court's approach on page 148, where it starts discussing at the paragraph, left-hand side at the bottom, saying, well, there have been different positions. For one approach, which was already mentioned, is to say fundamental rights are basically against the state and not that they are not relevant in private law relationships. The other approach would be they apply everywhere to the same extent, and the court does find a bit of intermediary position. It's the third paragraph on the right-hand side, page 148. The court says, but far from being a value-free system, the Constitution erects an objective system of values in its section of basic rights, etc. And then it says this system of values must apply as a constitutional axiom throughout the whole legal system. It must direct and inform legislation, administration, and judicial decisions. So this idea, it's basically that we find something similar in the Swiss constitution for the Swiss students, in a way that is an influence of Lüth and German legal doctrine. Our constitution says that Article 35, paragraph 1, that fundamental rights must be realized in the whole legal order. So, and here the court tells us how. So when you interpret private law, you have to interpret it in the light of the Constitution. Judges, when they render decisions, they have to take fundamental rights into account. And that seems maybe nowadays as something not particularly revolutionary, but it has expanded dramatically the impact and the scope of fundamental rights. And it's something I've observed that generally, if you look through it with a historical lens, private law used to be the main domain. This is where a lot of scholarship was done, and doctrine, etc. And public law, in a way, gained in importance later. And sometimes I can also see that can create resistance from private lawyers, saying, what the heck are you meddling again? With your fundamental rights in something which is private law. What is the problem, etc.? So the problem is Lüth. Thanks to Lüth, we have this approach. I would say, I don't think it's a problem. I think you understood that. But the Constitution is not just about litigating an individual against the state. It's also an objective value order to be taken into account in the whole legal system. So that's, I would say, an important impact of Lüth. Then a question, it's also known in freedom of expression because it talks about the values underlying freedom of expression, a famous passage. I think you may have found it, where the court... Did anyone found the passage about the importance of freedom of expression? I think so, yes. When they quote Cardot's words.
Yeah, the basic right to freedom of expression, the most immediate aspect of the human personality and society, is one of the most precious rights of man.
So, and then it goes on. So you have the argument from self-development. It's important it's precious to be able to speak your mind. And then it's absolutely essential to a free and democratic state. Comes back the argument from democracy. And this idea that the conflict of opinion is a vital element of democratic society. So we can see this idea. It doesn't mention a marketplace of ideas, but we need different opinions in a democracy which will confront each other. And from there, it's how public opinion is formed, and hopefully sound decisions are taken. So this is a seminal quote, basically, why do we protect freedom of expression? Lüth is often quoted for that. Then there was another difficulty. When you read Article 5 of the Basic Law, take a look once and you have the other reader where you have the provisions. Article 5 basically says protects freedom of expression and then subjects it to limits from legal provisions in general laws, laws concerning the protection of the use, and laws protecting personal honor. That's it. This is what it says in terms of limiting freedom of expression. If you compare this, so this limitation clause, so freedom of speech is protected, but it can be limited by general laws and other laws, etc. You compare it, for example, with the European Convention, would you say that something is missing? If you had to codify or identify the conditions which need to be respected to limit freedom of expression, is it good enough to say, well, there is a general law limiting free speech? Well, what else? We looked at Zurich cases like that. What else did the European Court usually examine? What would the Canadian court do? Would it just say, there's a law limiting free speech, fine. I can go home, I don't have to basically do more. Anyone? What is missing there?
I think you need to define what's general law, because that's not necessarily common feature. Do we consider like civil law here as a general law that can impose limits to the fundamental rights, or is it just criminal law? So it's not really.
So you have an issue. It's quite complicated. I will not go much into it. What are general laws? I think the basic idea behind is you shouldn't have a law which will just criminalize one opinion. So it's not exactly the same as content neutral, but the idea being you will protect some relevant legal interest. Defamation laws are also general laws. But the aim of the law is not just to say, there's an opinion I don't like and I will just target this opinion. So you can say the BGB, the civil law, the criminal law code generally, it's very rare that this is really a point of discussion. But would you say it's good enough to say, well, to limit free speech, which we see if the law says something, as soon as the law provides for limits, fine? Yes. So basically, you've given the court solution. We will return to it. What is missing if you compare it with article, for example, the European Convention, the restriction needs to be prescribed by law. This is what we have here, right? We have the general law, but that's the basic idea. But then you need to have a legitimate aim. And that's the most important thing. It has to be necessary in a democratic society, proportionality. Because otherwise, if you just say the law can, as soon as the legislature wants to limit free speech, it can do so without limits, you basically don't give, the right is basically at the discretion of the legislature. So the Constitutional Court is basically aware of this. And on page 148, we first have this passage stressing the importance of freedom of expression. And the court didn't put that in just because it's nice, it reads well, and so on. It is an important part because it justifies then the court's approach. The court continues, given the fundamental importance for the free democratic state of freedom of expression of opinion, it would be illogical for a constitution to make its actual scope contingent on mere statute. The right is too important to leave it at the discretion of the legislature, so we need to build in additional safeguards. And what are these additional safeguards? It was one of you mentioned. The general laws, which have the effect of limiting a basic right, must be read in the light of its significance and always be construed so as to preserve the special value of this right. So basically, what does it mean? The general laws have to be interpreted in the light of the importance of freedom of expression. German doctrine also uses basically this concept of Schranken, There are limits to freedom of expression, but these limits are limited. They are limited by the importance of the right. And when you look at the rest of the case, you can see that basically the court introduces also a proportionality, a balancing analysis. But it's interesting, it's not in the Constitution. The Constitution just talks about these general laws, and taken literally could mean that as soon as a law is adopted which limits free speech, courts would have to say, fine, the legislature made its call and we have nothing to say about it. So the court here interprets or builds, I would say, limits into the limits by saying, and it's this passage on page 148. And then the court also gives some, what that concretely means, it's a balancing of interests. You will have to balance freedom of expression, its importance, against basically the values protected by the general law, which can be defamation, it can be reputation, it could be, as here, the economic interests of Harlan to show his films, etc. Now, a question arises. So we have a balancing approach. Balancing, it's not always so clear which way will the cookie crumble. Does the court tell us something? Does it give some guidance how this balancing has to be done? What do we need to take into account? Or maybe what was the outcome here? Which way did the cookie crumble here?
They said where the formation of a public opinion on a matter which is important to the general welfare of the public is concerned, private interests must yield. And so, because the matter concerns the public, and then the private interests, like the economic interests of the company, had to yield to the interest of the public to free expression and the expression of this man's opinion on the environmental ideas in the public sphere.
So you've identified the important factor here is to say, you basically look, what is the case about? Is it about, again, a general interest? Or is it just a private dispute? So is it just about economic interests? When we apply it to Lüth, what did the court say? Was it about a public interest, or was it basically economic interests? Lüth wanted people to watch his own films. He didn't want them to go and watch Harlan's films. He said, great, let's get this competitor out of the way. So clearly here the court felt it's about a public interest. It's not that the Lüth wants to, I don't know, increase it's not for his economic gain, but he's actually, what he's saying is this is a catastrophe. What image are we portraying to the world if, you know, after World War II and the Holocaust, we let a filmmaker like this play his films again? So the court considers that this is basically of public interest. And in such a case, the court says it twice on page 148, and also it's very bottom, second last line, and also on page 149, top paragraph on the right, the court basically says if it's about a public interest, there is a presumption in favor of freedom of expression. So yes, there is a balancing. It doesn't mean that it's already clear that free speech will prevail. But if I had to use an image, I would say that the scales are tilted in favor of freedom of expression. It's a presumption, and you would need very strong reasons to say, well, actually, here it's the other side. it's Harlan who would win. If it were purely a private dispute, if it's like a competitor trying to make an economic gain, then the court would look at it differently. And I also thought it was quite interesting, the court, it's 149, the very last paragraph, where the court also says, well, these private interests must in principle yield. And then the court's answer is, well, in such a case, if your private interests are concerned, you can make a public reply. Public opinion, just like the individual opinion, is only formed through the competition of freely expressed opinions. So it's a bit a counter-speech paradigm we saw in the US, to say the general remedy should be counter-speech, not enforced silence. So Harlan here can come forward, can defend his point of view, but it's not the law here. Suing, basically saying Lüth committed a boycott and has to pay damages, goes too far. Can you see parallels between this case and what we, if you look at the Canadian law, would you see parallels? So I see the parallel there as well, that it's all about what is the speech about. Is there a matter of public interest? Then basically, we saw in the common law you can get away in defamation cases if you acted reasonably. It will not be defamatory. And here there will be a presumption in favor of freedom of expression. Again, the question which may arise is what is of a public interest, what is not of a public interest. I will give you an example, you tell me what you think about it. Let's take Burger King calls for a boycott against McDonald's, saying that McDonald's is applying unfair labor standards, is polluting the environment, etc. What would you do with this? Public interest or done for economic gains? It has not really been resolved, so any idea is welcome.
I don't know that I have an answer, but I think the fact that it's Burger King suing is very different than if it was the workers' union of McDonald's that would be suing. Because there's a clear conflict of interest in Burger King bringing a suit against their main competitor.
So we have that, we can say, well, Burger King probably has an economic gain. I think it's very unlikely that scenario, because probably they won't be that exemplary either in terms of labor standards. Okay, but either you look at the motive and you say this is mainly economic, and so, well, we should not apply a presumption of free speech, or you might say, well, actually, it's more about the content of the speech. It's more about labor standards and all this, and maybe they do have some knowledge which other companies may not have, or other actors of civil society. So there is some point in bringing it forward. So this is sometimes something courts struggle with. Or what there were also cases in the US, Nike versus Kasky, famous litigation, where basically Nike ran ads where they would say, this is not actually, but it goes a bit in the same direction, that they are very respectful of labor standards and they doing everything right. So it wasn't an advertisement like, buy Nike's shoes, but editorials, etc. And the citizens sued Nike, saying this is an act of unfair competition, you're lying. And there were debates, how should we classify that expression? Is it purely commercial expression? Obviously they don't do so because they think they have a commercial interest, but still at the same time it was about public issues. So, sometimes it's not always so easy to classify the expression. But I would say it was not so difficult in the Lüth case. So Lüth, just if we wrap it up, important to understand that it brings in the whole, fundamental rights as principles to be considered. In private law relationships, it's this passage, it's an objective value order, etc., the Constitution. And we have to interpret private law in the light of fundamental rights. This then is applied also to basically make the limits tighter to freedom of expression, to say it's not good enough that general laws can limit as such freedom of expression. We have to bring in also this balancing. We have to interpret general laws in the light of freedom of expression. I think that's the second important point. And third, again, a judgment very much focusing on this argument from democracy. If it's about the public interest, there's a presumption in favor of freedom of expression. Any questions on it? Really a seminal judgment.
So when a case like this, well, the first thing what you do is decide if it's public or private interest, and then after that, consider the next one.
So you're saying how important is this classification?
Is it the first thing they would do when looking at considering the case, for example? Like, is it a case of public interest or is it private?
I think it will be a factor when you basically they will probably first look, is it about is there a conflict between fundamental rights, like, or between an interest protected by private law and freedom of expression, and then they would say, well, we have to balance these two rights, and they will try and identify factors for the balancing. And if it's about the public interest, you would need to there would be a presumption in favor of freedom of expression. So in a way, this public interest comes back in many jurisdictions as a criteria. I know there has been some criticism. Some scholars think that is too much focusing, too much weight given to public interest. But it will bring me also to the European Court of Human Rights. When you look at the case law of the European Court, clearly these considerations play a role as well. And that would like to give you a few explanations about the European Court of Human Rights. So the European Court has quite a lot of case law on reputation, etc. And to understand the significance, a lot of a traditional conception was to say, if you criticize the government or the president, that's particularly bad. These people represent the nation, and so often laws actually had the opposite approach, saying we protect the president or politicians more than we protect ordinary citizens. And I think when you look at the Human Rights Committee, it will still, so we're on a global level, criticize, for example, some states because they have something like lèse-majesté. If you insult the king, it's particularly bad, etc. So the European Court stepped in and said, no, it's actually the opposite. It's not to say we protect the reputation of these people particularly, but it's the opposite. They need to bear more criticism. It's about democracy, it's about accountability, and this is what we find in Castells versus Spain, where it was basically a case, I think, where it was a criticism of the government, and the court says, well, the limits of permissible criticism are wider with regard to the government than in relation to private citizens or even a politician. Government has a dominant position, and we could say in a democracy you have to be able to criticize government. But I'm just pointing out it seems obvious to us, but it was not obvious to make this shift and say, well, no, they are not particularly worthy of protection. And you can certainly imagine some politicians nowadays who would defend that point of view. It's particularly bad if you talk badly about me. That's discrediting the whole nation, etc. Lingen's a case in the same direction, where this time it's about politicians. It was a case, I think, where Lingen's was a journalist basically talked about the chancellor and called him opportunistic, basically no moral values, etc., because he was trying to make a coalition with the far right. So basic opportunist, etc. There was a lawsuit basically against the newspaper, and the court there basically said again that or added that political debate is at the very core of the concept of democratic society. It is, prevails all over throughout the convention, and again, the limits of acceptable criticism are accordingly wider as regards a politician as such than as regards a private individual. Interest of open discussion of political issues. And also important, the court introduced here this distinction between facts and value judgments, saying, it's not, if I call someone an opportunistic person, this is a value judgment, that's an opinion, that's not a fact, that's not something you can prove. Because the problem was the Austrian law, basically the Austrian courts had said you have to prove what you say. So the courts, the European court said you can't prove this, it's a value judgment, there you have to show that, I would say there's still some basis to what you said, we can understand. It's a bit like the fair comment. Why you call him an opportunist. It's not just fallen from the sky. But also important, this distinction. You can't be as strict with value judgments as with facts. And I would say the first cases which were about defamation, it was always basically cases brought under freedom of expression. Someone complained, the press, etc., that they were silenced, they were not able to criticize a politician without incurring sanctions. Then later on, the court started getting cases which was basically the defamed person which took the case to Strasbourg, saying, well, we have been here, hurting our reputation, etc. And the case law evolved a bit. In Lingens, when you read these cases, the court never talks much about a conflict of right. It doesn't talk about Article 8, as a limit to freedom of expression. First, Lingens, Castells, it's about protecting free speech. Later cases, because people bring it under Article 8 as well, the court basically recognizes that in these cases there is a conflict of fundamental rights. You have, on the one hand, freedom of expression, which also is important for democracy, so it also has a public interest function. And on the other hand, you have basically the right to respect private and family life, and that includes also reputation. But, says the court, you still need a certain level of severity. So there is a certain threshold to say, well, that your reputation has been tarnished. Also important, and the court says it in the two judgments you read for today, that basically the outcome of the case should not vary, whether someone brings it under Article 8 or whether it's brought under Article 10. It's each time a conflict of interest. Why does the court stress that? Because commentators were saying, and I think they were not entirely wrong, that often the right which is invoked gets a better chance, because you take the other right just as a limitation. So now the court says they both have equal right, the outcome should not vary a priori, there is not a hierarchy, but you will take into account then also certain factors, and for freedom of expression, the chilling effect. The chilling effect typically could come in also if you have too high sanctions, etc., too high damages, and so on. So the court now basically cases can be brought under Article 8 or Article 10, always involving either privacy or reputation. Now when we look at this balancing between these two rights, I have given you two cases, von Hanover 1 and von Hanover 2, because actually there has been an evolution between these two cases. Has anyone seen any changes? Each time it's about privacy, but the court applies the same framework to reputation. It's each time Caroline von Hanover complaining, I'm being haunted by the paparazzis wherever I go, they turn up, they take pictures, they sell them, etc. And there was also another implication, was because German law was very favorable to freedom of expression, these pictures were often then sold to other newspapers elsewhere. but they were first taken in Germany or first published in the German press. If we take von Hanover 1, what did the court basically consider if you had to sum it up? Or do you see a disagreement in a way between the European Court and the German Constitutional Court?
In the first one, you said the phrase was used to entertain rather than to genuinely inform, and so because it was entertainment rather than that sort of informing, the right to control the image of private life prevailed over the right to freedom of the press, they say, I think. And whereas German courts said that because it was supposed to also like a public figure of the public interest, the freedom of the press prevailed.
So I would say you're right in saying that the German court's approach was very much saying, well, here, even if it's just entertainment, infotainment, etc., this Caroline von Hanover is a public figure par excellence. Everyone knows her, etc. So the German approach was to say, well, unless she is in a secluded space where she has a legitimate expectation to, well, no one will take pictures of me, otherwise she's a public figure and she has to rough it. So that was one point of view. The European Court, I'm not sure the court explicitly said if it's entertainment we will not protect it, but what did it give a lot of weight to? Why did it, what was at the end of the day important for the court to say, well, actually it's Caroline's rights, privacy rights, which prevail?
They emphasize that she exercised no state function, and that they kind of use that as like a way to indicate that maybe she's not a public figure par excellence, and that and to try and like show that maybe this was more entertainment than actual something in the public interest.
So clearly they did attach a lot of weight to this. Does she exercise an official function? Saying, well, actually, she's not like someone like, I don't know, the government, a member of the government, etc. Yes, she has a representative function, but that does not justify that, it's not so important to know what she's doing. There was someone else raising their hand. I think you were first.
Contributing to the debate on democratic society and reporting details of a private life which don't concern everybody.
So that's another distinction which stepped in. And you can see, again, it's about what is of a public interest in a way. And we can see the German approach was to say what? Did they say it's great to amuse people about private lives? That's what we're doing a bit, as the Romans said. Panem et circenses, we need to feed these people something to keep them busy, so it's about private scandals. Who would like to defend the German Constitutional Court's vision? What did they say in a way?
They said that also the private life is interesting because people like to identify with public figures or see if they behave privately like they act publicly, and therefore it's also interesting to see what they do once they go home.
I would say, but maybe as I understand it, they say also, they do not say protect it because it's fun, because everyone's interested in it. They try to make the case, it's a very broad interpretation of what is in a public interest by saying we cannot distinguish information and entertainment. We have infotainment, and these people, they are celebrities. They influence how we, they are role models. And that might also influence our opinions on certain matters. And if you say they are role models, then it's important to see, do they actually behave the way they portray themselves? And so the private life is important as well. I mean, you could make a similar argument for politicians. One could imagine, let's take someone who is a politician, and there were cases like that also in Switzerland. You run for the Christian
Democratic Party. And it turns out you have some illegitimate children. It's your private life, but you may not be so credible as a politician anymore. So when we talk about politicians, it's one approach is to say we care about how they do their function. This is important. And the private life is something else, or if they have marital difficulties, whatever. Or the other thing is to say we look at them as a character, as a role model as well. And then the German Constitutional Court uses that also for these public figures, so not just politicians. Yes.
But I would argue that in the case with the Caroline von Hanover was that I think she was born into a royal family, if I'm not mistaken, so she didn't choose to be in the public life, so to speak, and she did not have any public functions, whereas a politician chose to be in this life and is actually has an influence in his policy.
So you're saying we should also consider that these people did not choose. They were born in that family and they get haunted by the press. And I think certainly that's something you could take into account. So far, the whole reasoning I have focused it on, is it in the public's interest or not? By trying to show that the German Constitutional Court, in my view, takes a very broad view of, infotainment, everything is in the public interest, hard to draw the line. And the European Court in von Hanover takes a more narrow perspective, saying she doesn't run this country, she has not an official function, she just gets persecuted by these paparazzi. And the court says, look at the titles, they are so innocuous, and it's, well, she's that almost falls over on her nose, who cares? But it's important, there were other factors mentioned as well, so it was not the only factors the court looked at. But it did give a lot of weight to this official function.
I think they also have this part where the European Court says that the par excellence, description of her as a public figure, has then this criterion of spatial isolation. And it's too vague and too difficult for her to ever know when she's in private and when she could be photographed, because that's also part of her respect for her private life, is that she knows when she's at a function that she's representing somehow herself in public, but when she's at a private club and someone's hiding in the bushes taking photos, is she supposed to know that she's being photographed at all times, and that it was too difficult for her, if everywhere that she could be photographed is therefore allowable.
So that was an important factor, and Germany had to give up this approach of the secluded space. What happened after von Hanover won, it was really almost a war between Strasbourg and Karlsruhe. The Constitutional Court took it very badly. The president of the Constitutional Court basically gave an interview saying that this was a wrong judgment, and they later handed down a judgment in a different area, where they basically said that they conserve the last word. The last word how to interpret fundamental rights in Germany, it's the Constitutional Court. They are the sovereigns, and they were signaling they may not want to implement the European Court's judgment. And they also made the argument, if it's basically a private law relationship, like here again we're in private law, that basically there should be, and there's conflicts of fundamental rights, a margin of appreciation given to the states. Von Hanover too has to be read, I would say, some people say appeasement. The European Court says, yes, okay, we heard you. We don't want to give in entirely. So what did they do in von Hanover too? I would say already they identify a whole series of factors to be taken into account when you do the balancing. You will see they don't mention the official function anymore. That doesn't get much prominent weight. You have a whole, and look at these factors. That is something I could ask you how it's basically a balancing between both rights, but the court gives a whole series of factors to look at. It is, I just have to get to the right case. I'm still in von Hanover 1. You have the criteria, you have them on page 169. First, is it a contribution to a debate of general interest? How well known is the person? So that's more, is she a public figure? Not has the person got an official function. That is a difference compared with von Hanover 1. Prior conduct of the person, so if you invite the press to write about you, the court might say, well, you actually wanted to be in the press, so the content, form, consequences of the publication, the circumstances in which the photos were taken, that brings us back to if you're hiding in the bush and so on, that's not a good sign. So the court already defines these criteria, does not put so much emphasis on the public, on the official function. And another thing the court does, it's basically giving a bigger margin of appreciation now to the states, here to Germany. Did anyone see in what that margin of appreciation consists, or did you see a sign of saying, okay, we will not do too much second guessing, we step back a bit and basically what the court introduces is also something called procedural subsidiarity. You can see it on its paragraph 45 of the judgment. The court will basically, and 46 mentions the margin of appreciation. You can also see the margin of appreciation mentioned in paragraph 38. Procedural subsidiarity means the court will look with re-identified criteria you need to take into account when you balance both rights. And if courts have taken into account, the domestic courts did actually examine these criteria, we will not basically interfere too much. But if these criteria have not been examined, so if the domestic authorities just say, well, we look at the secluded space, then the European Court would say, I will do a strict review. But as long, and here the court, that is the appeasement, said, yes, you did a good job in Germany, you actually did look at the criteria of our case law, and then it's not to, the court is relatively differential. And I think that difference you can see where the court basically looks at its paragraph 38. Germany basically said there was one picture where the prince was ill and there was a photograph of his children skiing or something. And so the argument of the German courts was to say it's of public interest when the prince is ill to know what his children do, how they deal with the illness, and so on. The European Court, I think, was mildly convinced, because it says this is cannot be considered unreasonable. That wording doesn't say, oh yes, I agree, that's an important public interest. And the court then says, the court can therefore accept, I accept it, I don't fully endorse it, I can live with it, that the photos in question, considered in the light of the accompanying articles, did contribute, at least to some degree, to a debate of general interest. Okay, we accept that we can somehow link it to a public interest. We don't want war with the German Constitutional Court, so margin of appreciation. So there's really a change in, first of all, the factors, not giving too much weight to this official function, and second, the margin of appreciation, saying, okay, we will accept here what the German court's assessment. Von Hanover, there's also a von Hanover 3 case, so it's been going on, and there the court said more or less the same thing. It was an article with photos of Caroline von Hanover's private residence, I can't remember where, not in Monaco, and they rented it out. And they considered we accept it's a question of public interest when celebrities rent out their private homes. Well, how do you draw the line? What is, so we have here two quite different ideas. When is something of a public interest? But I thought it's also interesting to see how the European Court will check, will be an interaction with the domestic courts. It sometimes might change course when it sees there is too much resistance.